We're going to head right into our next session, which is Emerging Legal Trends with Jeff Grubb. We also have Ed Pyle from the SCSA, and Ed's going to be posing some of these questions. So Jeff Grubb, QC, is a partner in the Regina office of Miller Thompson LLP. Jeff?
Thank you very much, Kelly, for that very kind introduction. It really is a privilege and honor for me to present today to the Saskatchewan Construction Association and your webinar. Obviously, we would all like to be present in person, but that's not possible today. And so we will make the best we can with what we have. Now, I know Kelly had mentioned at the beginning that it was good that half of the people left to the other seminar. From my perspective, I'm not sure that was so good, but hey, as long as I've got half the people here, that's good. So just a bit of a correction. The pronunciation of my name is Grubb, actually, so no apology necessary, Kelly. You're not the first one to make that mistake. So I will get underway with what I would like to present today. Now, I do have a PowerPoint presentation. And so I'm going to pull up that PowerPoint presentation for you. We will walk through that. It'll probably take half an hour, 40 minutes or so. And then we will have some time for some questions, if that is okay. And if it is not, I'm sure Ed or Kelly will let me know and we can do something different. So let me pull up my PowerPoint presentation here. Okay, so today we're going to talk about some emerging trends, legal trends in Saskatchewan. I'm going to provide sort of the obligatory disclaimer that today I'm providing you with some information, not providing you legal advice. So if you do have issues around some of the items we talk about today and you would like some legal advice, I do recommend that you reach out to your lawyer about your specific situation. So today's objectives are to provide you with a brief update in construction law over the past year, since COVID, and you know what the legal landscape looks like, or how it's a little bit different in terms of the construction industry due to COVID. I'd also like to provide you with an update in relation to the labor and employment laws in Saskatchewan as it relates to COVID-19 and what has happened over the course of the past year. I'm sure many of you are familiar with some of these, but we will talk a little bit more about some of the detail of some of these new provisions. Also want to talk a bit about the dismissal of employees during the course of the pandemic. How has that changed? What does it mean? What do you need to be mindful of? That kind of thing. You know, all businesses, unfortunately, are encountering these kinds of issues in terms of, you know, they can't keep on staff, they've lost work, and they're asking questions about, well, what do we do? How do we tend to it? Also want to touch on the issue of safety in the workplace. I know you just had a presentation that talked about safety and technology and so forth, but let me talk a bit about safety in the workplace from a legal perspective, and some of the things one needs to be mindful of in terms of, particularly in light of COVID and what that has meant. Lastly, going to talk about a couple of items pertaining to returning to the workplace. You know, we're all hoping and hearing that we will be able to get back to the workplace, hopefully sooner rather than later. And what is that going to look like for employers when that happens? So let's start off then with update on changes in construction law. So not much of a surprise here. There are rather limited legal bases by which a COVID-19 related cost or schedule impact claim can be advanced by a contractor. Contracts, of course, mean everything in the construction industry. Obviously not unique to the construction industry. Contracts are important in many industries, but more so in the construction industry. So when you have a contract or a cost or schedule impact claim that arises in a circumstance, you really have to go back and take a look at your contract to determine whether there's any basis for a claim or not. Now, typically, there will be three avenues of approach when one looks at the contract to determine if there's any potential recourse. I'm now looking at this from the perspective of a contractor. One could also, I guess, take a look at it from the perspective of an owner, because again, the same principles would apply. One has to look at the contract. So if you do have a cost or schedule impact claim, and you're trying to figure out, well, what do I do or what can I do? There are really three key components that one has to look at in the contract. Firstly, is there a basis in the contract that talks about risk allocation, under which either the owner or the contractor assumes the risk? So look for a cost or a risk allocation clause in the contract. Two, is there a contractual right to an impact to the impact of a change of law? So does the contract contemplate what is to happen if there is indeed a change in law? Who's to bear the risk? Is it the owner? Is it the contractor? Is it somebody else? Does your contract speak to that? And thirdly, of course, is the concept of force majeure. Now, again, force majeure is a purely contractual right. Some people think that force majeure is external to the contract. Some people believe that it operates by virtue of common law or other law, whether it's in your contract or not, but that's not accurate. If there is a force majeure provision that's going to be applicable, it is in your contract. So let's start with the first basis for a claim, the specific contractual risk allocation. So the question is, does the contract include a clause that confirming which party assumes the risk and responsibility for performance of the contract? And here's an example of one where the contractor bears all the risk. And this is a standard clause that would be found in most construction contracts. And it says, except to the extent provided otherwise, pursuant to the express provisions of this agreement, all risks, so it specifically mentions risks, so all risks, costs, and expenses in relation to the performance by the contractor of its obligations under this agreement are allocated to and accepted by the contractor as its entire and exclusive responsibility. So obviously, if this clause is in your contract and the contractor is now facing extra costs and impacts associated with responding to COVID, they are not going to have much recourse as against the owner because they agreed in their contract that they would indeed bear all risks associated with that. So again, this is a circumstance where the owner might be happy with this particular clause, but the contractor may not be. Let's look to the second basis for which one might try to find in the contract if there's any avenue of recourse, and that relates to changes in law and the impact of costs. So is there a requirement in the contract that determines who is to bear the risk associated with a change in the law? So as we know, generally the most significant impact of COVID-19 on construction projects has not been the loss of personnel due to illness, but the time and cost associated with complying with laws enacted by provincial and federal governments designed to protect the public and limit the spread of the virus. So that's where, in the construction industry, most of the cost has been incurred, is simply trying to comply with the new regulations, safety provisions, etc. So one then has to go back to the contracts and ask, is there a compliance with applicable laws clause in the contract? So typically, most contracts will require a contractor to carry out and perform the contract, quote, in compliance with all applicable laws. Now, this means new laws coming into force from time to time, and that would include the cost of complying with more stringent health and safety protocols enacted in response to the pandemic. So again, if there is such a clause in your contract, typically the burden will fall to the contractor. And these are questions that are being posed more and more these days by contractors, subcontractors, and others involved in the construction industry, and indeed in other businesses. They're saying, we've got additional costs that we're saddled with. How do we deal with these? Is there any recourse that we have through other parties? The third item or approach, if you're looking to determine, well, what can we do, is typically the force majeure option. And it is colloquially known as sort of the act of God clause. The triggering events are typically, natural disasters, war, or other unforeseen events beyond the control of the parties. And the purpose of the clause is to identify, well, what are the rights and obligations of each party in these circumstances of unforeseen events. Now, again, as I mentioned earlier, this is an entirely contractual provision or entitlement. There's no common law right. There's no automatic right to it. So again, one has to look at the contract and ask and look and determine, is there a force majeure clause? And if so, what does it precisely say? Typically, a force majeure clause would actually allow the parties to interrupt the contract or suspend the contract for a period of time in order to deal with the unforeseen triggering event. In some circumstances, some force majeure clauses, for example, a labor strike will constitute a force majeure, be it a labor strike at the project itself or a labor strike with a major supplier of materials. That is sometimes a triggering event, and it affords the parties the opportunity to either suspend the contract or to do something different to manage that particular triggering event without constituting a breach of the contract on either side by any of the parties. So those are the three things that we are seeing in the legal profession that people are coming forward with and asking about is, well, what can I do in response to these additional impacts, costs and impacts that we're seeing? Can we pass them on? And the three items that I've just mentioned are the courses of approach that most often one would look to determine if there's any recourse. So with that, I'm now going to switch over to some of the employment law changes that have come into effect over the course of the last year with COVID. Now, one which I'm sure all of you are familiar with, because of course it's been in the media, it's been publicized, everybody's talking about it, is the public health emergency leave. So this was enacted by the provincial government at the beginning or towards the beginning of COVID last spring. And what the public health emergency leave is it's designed to provide an unpaid job-protected leave for employees who must isolate as a result of a COVID infection or being a close contact. So they have to quarantine, as well as those who have to care for their child or adult family member who are affected by a direction or order of the government or public health. So school closures would be an example of that. So the public health emergency leave applies if an employee is directed to isolate by their employer, the government, their physician, or the chief medical officer for Saskatchewan. So I'm just going to stop there for a moment and kind of reiterate and highlight some of the points of this particular leave. So this was a new leave enacted by the provincial government. It's an unpaid leave, so there's no obligation on the employer to pay the employee when they're on this leave. But it does protect the employee. So while they're on this leave, the employer can't fire them because they're on this leave. It's like being on maternity leave. It's a job protected leave. The leave also extends for as long as the employee is ordered to stay away from the workplace. Now, again, they can be ordered to stay away from the workplace by any of the employer, their physician, the government, or the chief medical health officer. So the employer has an ability here to say to an employee, we need you to stay home because of a COVID issue. And they would then be entitled to this public health emergency leave. Now, if the employee wants to stay away because they've contracted COVID or they're in close contact and need to quarantine, typically, pre-COVID, an employee would need to provide their employee with a medical certificate to justify their reason for leaving or needing the leave. In the case of COVID and the public health emergency leave, the employee does not need to provide a medical certificate in order to access this particular health emergency leave. By its very nature, it is an emergency leave, and typically employees may not be able to get certificates in a timely fashion. And so they do not need to do that as it relates to COVID-19. Now, if they're looking for leave for some other medical reason, they need to take time off for to get surgery or for stress or whatever, well then, of course, the regular rules still apply and the employer is entitled to ask for a medical certificate in that circumstance. Another leave that has been enacted recently was a special vaccination leave. And this was enacted by the provincial government just last month, the middle of March. And this is a paid leave. So unlike the public health emergency leave that's unpaid, this particular one is a paid leave. And this particular leave entitles workers to 3 consecutive hours leave during work hours to receive a COVID-19 vaccination. Now, they're entitled to more than 3 consecutive hours if the employer determines the circumstances warrant a longer break from work. So obviously, this vaccination leave is designed to encourage people to get a vaccination, and it's also intended to require employers to give employees time off to go and get a vaccination. This is not unlike, or it is similar, I should say, to giving people time off to go to vote at election time. Now, the workers do not lose any pay or other benefits while receiving a COVID vaccine or COVID vaccination, or taking time off to receive the vaccination. Other changes over the course of the last year that have changed sort of what was the status quo in workplaces relate to temporary layoff. So the pre-COVID rule was that if a company was looking to lay off an employee, they needed to provide that employee with either reasonable advance notice as prescribed in the Saskatchewan Employment Act of that layoff, or pay in lieu of that particular notice. Well, during the pandemic, that requirement was suspended. So during a public emergency period and for 2 weeks following the end of the public emergency period, notice of layoff or pay instead of notice of layoff is suspended. So you don't have to actually provide advance notice or pay in lieu of advance notice to individuals you wish to lay off during the public health emergency leave. Now, there was also a pre-COVID requirement as it related to a group dismissal. Now, a group dismissal in Saskatchewan is defined as the dismissal from employment of 10 or more employees in a workplace in a 4-week period. So if you're looking to downsize by 10 or more employees within a 4-week period at a particular workplace, that would have ordinarily triggered this group dismissal obligation. And that obligation was to provide, again, additional notice over and above the layoff or dismissal notice that is ordinarily applicable. There's a group notice layered on top of that. And in addition, the employer was required to inform the minister and unions and that sort of thing. Well, most of that has been suspended again during the pandemic. The only obligation now is that the employer must notify the minister afterwards, as opposed to beforehand, if there is this group dismissal circumstance. So those were some of the changes that were made during the course of the past year that impact, obviously, construction employers and other employers as well. Now let me switch a little bit to dismissals. So I talked a few minutes ago about the suspension of the temporary layoff notice requirement, so that if you laid off an individual, you didn't have to provide the notice or the pay in lieu of notice prescribed under the Saskatchewan Employment Act. That is not applicable or that suspension is not applicable if the employee is dismissed. So the same rules that were in place pre-COVID also apply during COVID if an individual is dismissed. Now, there are minimal requirements set out in the Saskatchewan Employment Act that must be complied with in the case of a dismissal, and it's all contingent upon how many years of service the individual has with the employer. And so it's a rather formulaic and prescribed amount as is shown in the screen before you at this moment. Now, there's a caution to be made. And as most things with the law, there's always, it depends, or there's an alternative, and there's a caution here. The requirements under the Saskatchewan Employment Act in the case of a dismissal that are prescribed here are the bare minimum. In addition to these requirements, employees will also typically have an entitlement to common law severance. And so an employer, when they're looking to dismiss an employee, must be mindful of both the obligations under the Saskatchewan Employment Act, which is the minimum, and the obligations at common law. So the common law still applies. And so one must think of the requirements in the Saskatchewan Employment Act as a floor. You cannot provide an employee with less than what the Saskatchewan Employment Act requires, but in many cases, the employer may be required to provide more. This is often referred to as pay in lieu of reasonable notice. So unlike some countries in Canada, there is no at-will employment. Employees are entitled to reasonable notice of termination. So let me stop there and explain what I mean by that. The employment in Canada, in Saskatchewan, the relationship between an employer and an employee is a contract. So much like a contractor would have a contract with an owner, an employee has a contract with their employer and vice versa. Now, in many cases, that contract may be verbal. There may be nothing in writing. In some cases, it may be in writing, but fundamentally, it is still just a contract. Now, what the law has also said about these contracts is that they can be terminated by the employer in one of two ways. So an employer can terminate an employment contract for what's called just cause or for cause, or alternatively, they can terminate the contract on a what's known as a without cause basis. Let me explain briefly what that means. If the employer looks to terminate an employment contract for cause, that means that the employee has done something egregious to warrant the termination of the contract without any compensation. An obvious example would be an employee guilty of theft from the employer. That's an egregious breach by the employee, and the employer would be entitled to terminate the contract for cause and not pay any compensation or severance to that employee. However, the employer is also entitled to terminate the contract on what's called a without cause basis. Now, what that means at law is the employer has decided, for whatever reason, that things are just not working out with the employee and they want to part company. Or alternatively, the employer has had a downturn in their business and they just don't need the employee anymore. They can terminate the employment contract on a without cause basis. However, when a contract is terminated on a without cause basis, the employer is obliged and obligated at law to provide the employee with what is known as reasonable notice. So you have to provide notice to the employee that their contract is being terminated, or alternatively, compensation in lieu of that reasonable notice. So, if an employee is entitled to, just picking an example, 3 months of reasonable notice, an employer that is terminating the employee on a without cause basis would have to inform that employee that in 3 months' time, your employment is being terminated, or alternatively, your employment is being terminated today, but here is 3 months' pay. So that's how that works. Now, the concept of reasonable notice is meant to give the employee time to find replacement employment. Now, what this reasonable notice is a bit of an amorphous topic in the sense that it's not formula driven. Now, the first part of the reasonable notice period is formula driven. It's the Saskatchewan Employment Act provisions I just showed you a few minutes ago, but the common law portion is not formulaic. It's very much dependent upon a number of factors. Now, parties may agree in advance what the proper reasonable notice is required through a written contract of employment, subject, of course, to the contract complying with minimum employment standards. So there is, and I'll make a pitch here, for the need for an employer to get written employment contracts with employees, is that they are able to define up front what a reasonable notice period would look like in the event that the employee is terminated at some point in the future on a without cause basis. Now, this common law creature that I talked about of reasonable notice, what are the factors that go into determining it? There are what in the legal profession we call the Bardol factors. Bardol was a case that identified the factors to consider. And in determining what constitutes or the length of reasonable notice ought to be is determined by the length of service of the employee, the age of the employee, the nature of the employment, the availability of other employment, and a host of other factors that may or may not be applicable in any given situation. So a court looking at this takes a holistic view of the particular circumstance and asks itself, given all of these factors, what is a reasonable time period for the employee to find reasonably comparable alternative work? And that is what the court would then conclude would be the reasonable notice period. Unfortunately, the economic impact factors of an employer do not often typically factor into the equation. So if, for example, the employer is simply downsizing because they have no work, that typically does not factor into the length of the reasonable notice that the employee would be otherwise entitled to. So whether the employee is being dismissed because of lack of work or they're being dismissed because they're just not working out, the reasonable notice period will typically be the same. Now, there has been a lot of musing and speculation and inquiry with the legal profession and others as to, well, what about the impact of COVID? What impact does it have on this reasonable notice period? Is it going to extend it? Is it going to shorten it? What's the impact when an employee is let go during COVID? Now from the employee's perspective, the argument is, well, it's harder for me to find reasonably comparable alternative work because of COVID, and therefore the reasonable notice period should be longer than might otherwise be the case. From the employer's perspective, they say, well, COVID is something beyond my control. It's part of the economy. Why should the employer have to bear responsibility for that in the event that the employee has to take longer time to find a job? Now, we're still relatively new into the COVID experience from a legal perspective or from a court decision-making perspective. And so there are not many cases yet that the court has dealt with on that particular issue, but I did find a couple. And there was one case was out of British Columbia, the Goats case that is currently on your screen. Now, this was a decision decided by the British Columbia Supreme Court just a few days ago, last week on April 16th. So it's fresh off the press. And in that circumstance, the court said, despite the COVID-19 pandemic, based on the evidence provided by Cal Tire, there continue to be job postings for positions in the tire industry and in senior sales positions in other industries. The evidence does not support a limited availability of similar employment. Based on the evidence, I conclude that the availability of similar employment for someone with Mr. Goats's sales experience in the tire industry specifically and in senior sales positions more generally is good. So again, it was a matter of evidence. Just because we have a pandemic doesn't mean it's going to be difficult for everyone to find reasonably comparable alternative employment. And the court in this particular case concluded that notwithstanding the pandemic, the individual employee that was dismissed still had good opportunity to find work elsewhere, and therefore the reasonable notice period was not extended. A similar result was reached in the Iratakis decision that is now on your screen. This is a decision out of the Ontario Superior Court of Justice rendered on January 29th of 21, so just a couple of months ago. But again, it was asked this question about the impact of COVID-19 on whether the reasonable notice period should be extended. And the court here said, I have little doubt that the pandemic has had some influence on Mr. Iratakis's job search and would have been reasonably expected to do so at the time of his employment, his employment was terminated in late March 2020. However, it must also be borne in mind that the impact of the pandemic on the economy in general and on the job market in particular was highly speculative and uncertain both as to degree and to duration at the time Mr. Iratakis's employment was terminated. The principle of reasonable notice is not a guarantee bridge to alternative employment in all cases, however long it may take, even if an assessment of the time reasonably anticipated to be necessary to secure alternative employment is a significant factor in its determination. I must be alert to the dangers of applying hindsight to the measuring of reasonable notice at the time when the decision was made to part ways with the plaintiff. So again, there are a couple of cases that seem to suggest that that the courts are not looking to extend the reasonable notice period because of COVID-19. But I do caution that all of these circumstances are fact specific. And so in any particular circumstance, it may be open for an employee to argue that they should be entitled to a longer notice period due to COVID-19. Let me jump now to talking about safety in the workplace. Now, the primary duties of employers as it relates to safety haven't changed with the onset of COVID. The employer still has an obligation to provide a safe and healthy workplace. They still have an obligation to maintain an effective health and safety program and obtain input from the Occupational Health Committee. They still have an obligation to make sure that managers and supervisors are trained, supported, and held accountable for fulfilling their workplace health and safety requirements. They still need to oversee the health and safety performance of their managers and supervisors, and still need to make sure workers have information, training, certification, supervision, and experience to do their jobs. There, however, been differences in how employers approach these obligations. Now, one of the things to note is that all businesses must have a workplace illness policy. And this has been emphasized significantly since COVID. So illness policy, it is mandatory to have an illness policy. So if your policy does not currently exist, if you don't have an illness policy in your workplace, or it does not align with the COVID-19 recommendations, then the following should be included in such policy. Sick employees must stay home or be sent home from work. For employees housed in workplace accommodations, for example, work camps, sick employees must be confined to their rooms until cleared for re-entry into the workforce. Sick employees must use the Government of Saskatchewan self-assessment tool for COVID-19 and follow the subsequent directions. And when employees go home sick, their work areas must be cleaned and disinfected. So those 4 points that I just mentioned must be included in illness policies that employees are obligated to have. Now, another issue is injury or fatality. Now, again, that really is not anything new or associated with COVID. There has always been a requirement in the workplace that if there is an injury or fatality, that the employer must immediately report the incident to occupational health and safety. Many employers, or most employers, I'm sure, would understand and know that obligation, but it is important to emphasize it, because in the heat of the moment when things are happening, somebody's been hurt or worse, it's sometimes easy to forget that OH&S needs to be contacted immediately. And that's an obligation of the employer. It's not an obligation of the employee or anyone else. OH&S will then send an investigator, and employers are obliged to cooperate in providing information to OH&S. Typically, the OH&S investigator will interview people, they will take information, they will ask for documentation, and an employer is obliged to provide that information. Now, what about the WCB, Workers' Compensation Board, and COVID-19? What happens there if there's a COVID-19 related injury or contraction of the virus? So the WCB has directed that an employee is only eligible for WCB coverage if they contract COVID-19, are off work, and their employment puts them at greater risk of contracting the virus than the general public. So just because somebody has COVID-19 doesn't automatically mean that they're going to get WCB coverage. WCB says we need to understand that you're firstly working in an industry or an employment situation at which you are at greater risk than the general public. And an example of that would be a nurse. So if a nurse contracts COVID-19, the WCB proceeds on the presumption that it was contracted in the workplace as opposed to someplace else. If you are not in a high-risk situation or setting, then the Workers' Compensation Board will presume that the employee got COVID-19 outside of the workplace. Now, before I move to the next slide, I just want to talk briefly, because I know this question gets raised a lot. What can or when can an employee decide on their own that the workplace is not safe due to COVID-19 and they're just not going to show up? Except in very limited circumstances, employees cannot unilaterally decide to not show up for work because they are concerned about COVID-19. While employees need not work in an unsafe environment, the determination of whether a workplace is unsafe is contextual. In the context of COVID-19, it depends on what the employer is doing to maintain safety in the workplace. If all reasonable precautions are being taken by the employer, then it is unlikely that the workplace would be deemed unsafe. So it is a matter of context, and if employers are taking all of the proper steps in terms of requiring masking, the plexiglass, the social distancing, people must stay home if they have symptoms, all of those kinds of things, then it is unlikely that that particular workplace would be deemed unsafe, and the employee must show up for work. And if they are just simply concerned for personal reasons about the safety of the workplace, that is not satisfactory to relieve them from the obligation to show up for work. So let me turn to the last topic here, and we will then get on to questions. The return to the workplace. What are some of the things that employers are going to need to be mindful of when the workplace resumes to what hopefully it looked like pre-COVID? Well, one of the first things is, and I talked about this at the beginning, the suspension of the notice requirements in the case of a temporary layoff. So if you have employees that are on layoff and the public health emergency declaration is rescinded by the government, so there's no longer a public health emergency order in place, then those employees that are on layoff need to be recalled within 2 weeks. And if they are not recalled within 2 weeks, then they will be deemed to have been dismissed. And they will then be entitled to the notice or pay in lieu of notice prescribed under the Saskatchewan Employment Act. They'll also be required to this reasonable notice at common law that I talked about a few minutes ago. So employers need to be mindful if they've got employees on layoff, some decisions have to be made fairly quickly once the public emergency order is lifted. Another issue that is arising these days is the issue of vaccination, and can an employer compel its employees to receive a COVID-19 vaccine? Now, even though employers have an obligation to provide a safe workplace, it is likely not possible, legally possible, for most employers to require their employees to be vaccinated. Now, there's a possible requirement for employees in certain sectors, example, the healthcare sector, who are dealing with vulnerable populations. It may be possible for those employers to compel or require their employees to be vaccinated, but it's unlikely that most other employers are going to be able to impose a mandatory vaccination requirement for their employees. And if an employer seeks to compel an employee to receive a vaccination, there are a few concerns that arise. One, it may be viewed as a constructive dismissal in the sense that the employer is imposing on the employee a term of their contract that wasn't previously there, requiring them to undertake medical treatment that wasn't previously part of their contract. So it could constitute a constructive dismissal. In addition, there are human rights concerns. Some individuals may not be able to obtain a vaccination for religious, medical, or other protected reasons under the Human Rights Code, and trying to compel them to get a vaccination would violate those provisions. Thirdly, there are privacy issues. Obviously, medical treatment and obtaining a vaccination would be a matter of privacy for the individual, and having an employer compel an employee to get a vaccination may very well violate privacy provisions. So what is an employer to do? So if you can't compel employees to get a vaccination, there are alternatives that an employer can proceed with. One, the employer may be able to provide incentives to encourage employees to get vaccination. So one possible option might be the employer could say, look, if in the workplace we get to a point where 75% of the employees are vaccinated, everybody will get a $100 bonus or something like that. There's obviously education. So the employer can undertake an education exercise and try to persuade the employees that they ought to get vaccination. The employer can provide time off and recovery time for an employee to get vaccination. As we talked about earlier today, indeed, there's a mandatory requirement to provide at least 3 hours time off for the employee to get vaccination. So the employer can do a little bit more than that if they want, in order to try to cover off or try to encourage employees to get vaccinated. The employer can cover incidental costs associated with vaccination. So these are some additional things that the employer can do to try to encourage employees to get vaccination, but they have to stop short in most industries, and construction, I'm sure, would be one. They have to start short of making vaccination mandatory. And whatever the employer does, they should avoid the perception that the measures they are taking are punitive or intended to punish those folks who choose not to get the vaccination. So some final concluding thoughts before we entertain some questions. COVID-19 has obviously changed how the world deals with things, including in the context of the workplace. From my perspective, I think it is likely that some of the changes imposed by the pandemic will continue afterwards. Working remotely, it's remarkable to see how many businesses are able to effectively work remotely and indeed excel their businesses by working remotely. Virtual meetings like the one we're having today, I think a lot of that will continue. I don't expect that many people are going to be jumping back on airplanes for business meetings that are a one-day meeting in Toronto and then back home again. Hand cleaning and sanitizing and all those kinds of things that we become accustomed to during the pandemic, I expect will continue post the pandemic. And that will include in the workplace. And I think those are things that we can take as valuable lessons that we've learned from the pandemic and proceed forward. So with that, we can take some questions and address comments that you may have, concerns, other issues. I'm happy to help out in whatever way I can. So I'll turn it back to you, Ed, if you want to see if there are questions or if you have some questions.
Sure. We have a number of pre-submitted questions from our audience. You've already touched on a number of them. One question I'd like to ask you as we start to wind down here is, how does a construction company keep up with emerging trends? I've seen your company has an excellent website and blog. Are there other resources you can recommend, or what's a good way for people watching our conference to get in touch with you?
Well, certainly, Ed, looking and following blogs is a really good example. Not just my law firm, but lots of law firms across the country have really jumped all over this in terms of posting very current and recent information about changes in the workplace due to COVID and what employers need to be mindful of. So following blogs is a good way of doing that. In addition, our provincial government has done an excellent job in terms of dealing with this issue, and they post very regularly on the government's website updates, things to be mindful of, etc. So those are two resources that I really encourage employers to look to if they want additional information.
Thank you, Jeff. That'll conclude the question portion of our segment here. And I'll turn things back over to Kelly.